Good afternoon, everyone. Thank you for joining us for our 2020 Hemp and CBD update. I'm Sean Hauser, chair of the Hemp and Cannabinoid Practice Group here at Vicente Sederberg, and we're honored to be joined today by our FDA counsel, Will Woodley, and Dan Dwyer with FDA law and policy firm Kleinfeld Kaplan Becker, who we work with in advising clients in FDA-related matters, and is really renowned for their concentration in FDA-regulated products and advertising law. So we're so grateful to for their contribution of time and insight today as they walk us through the latest on FDA's progress with CBD, including their progress report to Congress, what it means for businesses, and how this all might be impacted by COVID-19, as well as other timely FDA updates, including OTC drug reform provisions that were in the stimulus package. And following the FDA update, I will discuss the state and local emergency orders, how they may impact hemp businesses, and my colleague Corey Cox will outline practical business issues and impacts and best practices in light of COVID-19, and some tips for operating in emergency environments. We welcome your questions and feedback, and we'll have some opportunities for questions after each section. And we've got a lot to cover, so I will turn it over to Mr. Will Woodley to give us an update on the FDA's progress with CBD.
So I'm going to spend just a few minutes talking about two subjects, not exactly related, but we're going to try to make a smooth transition between the two. One is an update on the FDA's consideration of CBD related issues and in particular use of CBD in foods and dietary supplements. And the other is to talk a little bit about FDA's response to the COVID-19 pandemic, again, with a focus on FDA's actions in the food industry and with respect to the food supply. So we'll get it going here, and I apologize again for my technical difficulties and the delayed start of the presentation. So I wanted to begin the update with a recap just to provide some context to what will be the main focus of the first part of the presentation, which is FDA's report to the House and Senate Appropriations Committees about various CBD issues. So it's important to understand that since the enactment of the 2018 Farm Bill, which fully descheduled hemp from the Controlled Substances Act, FDA's authority over hemp-derived products really hasn't changed. These products are still fully within the purview of the Food, Drug, and Cosmetic Act, and how exactly FDA regulates these products really depends on what product category the particular product lives in, and that in turn can be affected in part by the product's intended use, whether it's intended for use as a drug, a food, a cosmetic, or perhaps something else. And FDA determines intended use importantly by looking at the totality of the circumstances surrounding the distribution of an article. So the agency will look initially, at least, at the labeling claims of the product, at advertisements used to promote the product, but also at what the representatives of the marketer are saying about the product, orally or in writing otherwise. But really, it's a totality of the circumstances type evaluation, and it's important to understand that even if you label your product to look like it's within the category you want the agency to regulate it under, the agency is not going to defer to that. So as probably should be reviewed by now, just because you label your product as a dietary supplement or you position it as a cosmetic doesn't mean that the agencies can't still attempt to regulate that product as a drug. And those regulatory classifications are very important when talking about CBD for reasons we're going to get into in just a minute. So FDA has asserted since 2015 that products, CBD products is the way that the agency currently describes it in its questions and answers, and what exactly is a CBD product really is the most important question for which we lack answers at this point, but that CBD products can't be sold as dietary supplements under exclusion in the Food and Drug Act's definition of dietary supplement. And the agency bases this position on its determination, based on available evidence today, that CBD was not marketed as a dietary supplement or conventional food before FDA authorized substantial clinical investigations of developmental CBD drug products. And there's some confusion in this area about what drug products and what the dates are for determining whether FDA is right that there were no dietary supplements or foods with CBD before these triggering dates. But FDA has historically said that it's not just the clinical trials involving Epidiolex, the approved CBD drug, that apply here, but it really goes back to the 2006 phase 2 and 3 authorized clinical trials of GW for its Sativex product, which contained 2 active ingredients, both THC and CBD. That product is not approved for distribution in the US, but it is in other countries. So that's the agency's current position. It doesn't believe that CBD was marketed in food or in dietary supplements prior to the authorization of the Sativex phase 2 and 3 clinical trials from 2006. And then on the conventional food side, the agency has asserted since almost as long as it's made the same statements regarding dietary supplements that it's a prohibited act under the Food and Drug Act to add CBD to food and then to sell it in interstate commerce. And the agency similarly bases this position on its application of a sister provision to the exclusion in the dietary supplement definition, which says basically you can't put in food and sell it in interstate commerce an article that was approved as a drug or that's been studied as a drug under an FDA IND if it wasn't already in the food supply prior to, in this case, the initiation of those FDA authorized clinical trials. And even more recently, FDA has asserted its belief that in addition to the Prohibited Act problem, CBD is not a generally recognized as safe food ingredient, and thus it's not a legal food additive under the Food and Drug Act. Of course, and this should not be news to the group assembled today, some have questioned the validity of FDA's assertions regarding CBD in conventional food as well as in dietary supplements. And the agency has historically left open the possibility that rebutting information could change its analysis of these issues. And even today, FDA may recognize that certain CBD containing ingredients like milled hemp flour or full spectrum hemp extracts don't actually trigger these provisions because they aren't the same article as the CBD active ingredient in Sativex or Epidiolex. The agency has not publicly clarified its views here, but based on agency precedent and informal agency statements, and really even the agency's approach to responding to GRAS notifications for 3 CBD containing, albeit very low levels of CBD, hemp seed ingredients, the agency seems to at least acknowledge that just because there is CBD at a naturally occurring level in a particular ingredient doesn't mean that it's a CBD product that triggers the 2 provisions that I just previously discussed. And I've included on the slide a yet because it's important to understand that the agency has thawed a bit, or at least indicated that it's thawing a bit on this issue, and we'll talk about that when we talk about the congressional report in a minute. It's important to also understand that FDA has mostly, but not always, raised these issues, suggesting that a product can't meet the definition of dietary supplement or that a product is violative of the conventional food provision when it's issued warning letters to distributors or manufacturers of products, and those warning letters have been primarily focused on the fact that, according to FDA, those products are marketed with unapproved new drug claims on the labeling or on the website or in other marketing materials like social media posts. And the significance of this observation, I guess, is that the agency isn't running around saying you've got a otherwise compliantly marketed CBD containing supplement and we're going to assert a violation based on that alone. It's almost always come in the context of much more serious alleged violations of unapproved new drug requirements related to claims that products can be used to treat very serious diseases from schizophrenia to more recently COVID-19. That has caused some in the industry, and certainly some FDA statements from former Commissioner Gottlieb caused some in the industry as well to believe that the agency was exercising a so-called enforcement discretion policy related to these provisions, that for now the agency was going to allow these products to remain on the market despite its pronouncements and in the absence of disease claims, which would not otherwise be lawful for any other food or dietary supplement product. But the agency has since made it clear that there is no formal enforcement discretion policy, no safe harbor for marketing these products inconsistent with the agency's statements about the application of the prior drug exclusions for dietary supplements and conventional foods. But FDA does have the authority to undertake rulemaking to override, in a sense, both of these prior drug provisions for dietary supplements and conventional foods. The challenge here is that the agency's never used this authority before, so it doesn't really know what that process looks like, what exactly the agency is supposed to consider, and we'll get to that in a second. But it does know that because of the novelty of this, or the novelty of using this authority, it could take a very long time, and all rulemaking these days does anyway. And you know, for example, last year in congressional testimony, former Commissioner Gottlieb, among others, suggested that this process could take anywhere from 3 to 5 years if the agency were to create a legal pathway for CBD products as dietary supplements or for use of CBD as an ingredient in food marketed in interstate commerce. The agency in May of last year did hold a very long all-day meeting on cannabis issues, and CBD products were a huge focus of that. And the information that it gathered during that meeting, as well as from the associated docket, more on that later, should continue to inform the agency's views here. More recently, the agency had promised a fall 2019 status report on its consideration of, among other things, a potential rulemaking to fix this technical regulatory problem for CBD products in the supplement and conventional food categories. What we found, or what we received instead in October and November of this year, were a series of advisories, really consumer-directed advisories that the agency put out on its website, warning about use of CBD, THC, or cannabis in any form during pregnancy or while breastfeeding, and then later about additional safety-related concerns based on the published literature and based on information that the agency learned from the review of the Epidiolex new drug application, identifying issues such as liver injury, drug interactions, and male reproductive toxicity concerns related to at least certain doses of CBD. And the agency also used this opportunity to identify a number of unanswered questions that presumably the agency would want to have answered before it makes a definitive, takes definitive action on a potential rulemaking for CBD. And then meanwhile, of course, Congress continues to weigh various approaches to bring clarity to the situation, including potential legislative fixes, taking this out of FDA's hands, which at times agency representatives indicated might be a more efficient way to resolve this issue. And that really brings us to the report of Congress that FDA issued, I think it was on March 5th of this year. And that report was really the product of one of these legislative initiatives. So the agency wasn't a requirement, but was directed in an explanatory statement that accompanied the fiscal 2020 appropriations bill that was passed on in December of 2020. And this report directed the agency to, or excuse me, this explanatory statement directed the agency to tell FDA, or tell the congressional committees rather, what it was doing about assessing the potential for an enforcement discretion policy for CBD products. And the explanatory statement said, FDA, you should give us, give the congressional appropriations committees this report about your assessment of a potential enforcement discretion policy within 60 days of enactment of the fiscal 2020 appropriations bill. And the document that actually came out of this directive was much broader than just a discussion of the agency's consideration of an enforcement discretion policy. It touched on a wide range of issues issues involving cannabis products and CBD products in particular. And it really went through in a systematic fashion what the agency knows, what the agency wants to know, how under the various product categories within the scope of the Food and Drug Act, pathways existed or didn't exist or would require additional action to exist. And so reading through this document, you'll note a lot of information that the agency's already communicated on its website, in congressional testimony, and in webinars or other public presentations. But there were a few nuggets of what I viewed as new information that I think bear mentioning today. And as you'll see on the slides, I largely quote the language because I don't want to be accused of reading too much into it. I want to give you exactly what the agency said, and then I'll give you my thoughts on it. And the first is that the agency is evaluating issuing an enforcement discretion policy. This is the part of the report that actually directly responds to the joint explanatory statement directive, and that this policy would provide greater transparency and clarity regarding the factors that FDA is going to take into account when making enforcement decisions, when making decisions about whether or not to exercise its enforcement discretion. The policy, or excuse me, the report provides no details on the substance or and the timing of a potential policy's publication. But what I found, interesting here is that the report actually seems to contemplate that there could be such a policy in the future. It would have been, I think, fully responsive, maybe not well received, but fully responsive for the agency's report to say, we don't have any plans to do this. We don't, we have XYZ concerns that really give us pause about going down this road. But the agency does say that it's looking at this concept, and that to me is news in and of itself. Second, the agency said we're reopening the docket that accompanied the May 31st, 2019 meeting in order to continue to receive information that can inform regulatory decision making, which is good because the science in this area continues to evolve. Experts continue to learn more about what these products are and the biochemistry, and as well as how these products are being used by consumers in the marketplace, and all of that's very relevant to how the agency is going to continue to evaluate these issues. So the agency, very smartly, in my view, said we're gonna reopen the docket, hold it open indefinitely, and try to collect all the information that has been generated that didn't exist in May of 19, but certainly should be germane to these issues. And FDA followed through with its commitment in the report by formally opening the docket back up again on March 11th. Third, FDA said it's actively seeking information regarding what the concept of a full spectrum or broad spectrum hemp extract really means, how these products that are labeled that way are processed, and how they compare to CBD isolate products like Epidiolex, which is 98% CBD. And important to that statement about the agency wanting this information is why. FDA says that information could be critical to informing our evaluation of the regulatory status of such products. And reading between the lines, and I don't really think it's that much of a leap, this suggests that the agency thinks that something that's identified as a full spectrum or broad spectrum extract might be different, might have a different regulatory status than an isolate product, and that could mean that a full spectrum, or at least certain full spectrum or broad spectrum hemp extracts, are not excluded from the dietary supplement definition as a result of the prior FDA authorized studies of Sativex and Epidiolex, that there's a distinction between those articles and full spectrum or broad spectrum hemp extract. So I'd say this is incremental progress toward FDA formally acknowledging that there are differences between hemp articles that may contain CBD but that are not CBD isolate, I'd point to, again, the GRAS notification decisions regarding those hemp seed ingredients that did contain CBD. That was in the lab reports that were submitted in support of the notifications. Yet FDA didn't say those products are unlawful, and that those ingredients couldn't be used in dietary supplements. And so all this is to say that slowly but surely the agency seems to be moving in the direction of acknowledging what many in industry have been urging it to do, which is to say that just because something contains CBD as a constituent, a natural constituent, doesn't mean it's the same article for these purposes as Sativex or Epidiolex. So certainly more to come, and that will be one of the interesting points to follow as the agency continues to engage on these issues. Fourth, the agency says we're working to establish a clear process by which companies can submit proprietary information about specific products to help inform the agency's rulemaking and other regulatory decision-making processes here. And you may be asking, what is that all about? But in the public dialogue, oftentimes hashed over, through trade press articles, members of industry have said, we have data that can help you get comfortable with the safety of CBD in food products or in dietary supplement products, but we don't want to submit it to your public docket. We need to have a pathway by which we can get you that information that will allow you to take the next step and initiate rulemaking or perhaps issue an enforcement discretion policy. And here the agency heard those concerns and said, we're going to establish a process by which you can give us that information. It's going to be treated as confidential commercial and trade secret information that will inform our thinking, but that will protect your intellectual property. So the industry asked for it, and in this case, it appears that the agency is going to be responsive. And then last among the so-called nuggets, I wanted to note that the agency talked a little bit about the factors that are being weighed as it considers a potential CBD rulemaking. And historically, the agencies looked really at two, or talked really about two. One would be safety. The agency has made clear that it wants to be sure that if it opens up a pathway for food or supplement CBD products, that the companies who go down that pathway actually can comply with the default safety requirements of the Food and Drug Act for those product categories. Sharon Mail in particular has made the point that the agency doesn't want to give false hope and say that this pathway is available, but no one can actually satisfy the requirements and market these products compliantly. And I think members of industry have taken issue with the idea that safety should be a consideration for the rulemaking process, and that the default safety provisions in the law should take care of that on the back end. But the agency is obviously not in agreement on this point, and really wants to have a good sense for whether there's a potential safe CBD product before it opens the gate here. The other is preserving pharmaceutical development incentives, and that's really one of the key reasons that these provisions are even in the statute to begin with. They want to make sure that, or Congress wanted to make sure that adequate incentives remain for companies to continue to innovate in the pharmaceutical space with these ingredients once the first company went down that pathway, as would be the case here for CBD in Sativex and Epidiolex in particular. So those were the two factors that seemed paramount in the agency's thinking over the years on this subject. But this report introduced three more, and I somewhat cynically would describe at least two of them as veiled or implied requests of Congress in return. So the first is that FDA says that there's really nothing in the law that gives the agency the authority to require individual market participants to tell the agency what individual products they're making and selling to consumers. Unlike in the drug or medical device or even tobacco product areas where there is a product listing requirement, there is none for foods and there is none for dietary supplements. And the agency here seems to be saying that limits our ability to provide comprehensive oversight over CBD products that would be marketed as supplements. And I think the veiled request is, so Congress give us that authority to impose a mandatory product listing requirement for dietary supplements. And that's a debate for an entirely different day. And there's certainly a lot of strongly held viewpoints in the industry and in the broader stakeholder community about whether this is a good idea or would give the agency a useful tool here. But obviously in this report, the agency is saying it's a useful tool, and maybe it's a required tool if we're going to take on CBD in the supplement world. Second, the agency says, given the large number of products potentially in this space that would come under the dietary supplement umbrella, we would have to expend a lot of resources, and it could affect how we're deploying our existing resources and prioritizing our existing resources for all the other dietary supplement products we currently regulate. And to me, that's a somewhat veiled or implied request for money. If you want us to regulate dietary supplements, you need to appropriate more funds for us to do so, because, and I don't think it's any controversial observation, the CIFSAN in particular, the Office of Dietary Supplement Programs, doesn't have a huge budget to begin with, and this, I agree, would certainly create a much larger product base and regulated entity base if the agency were to open it up fully to CBD products. So, second request seems to be one for money. And then third, and a little bit more difficult, I think, to conceptualize, the agency talks about how it has concerns that if it's going to regulate these products as dietary supplements, that consumers need to understand what that means, both what it means in terms of how FDA regulates dietary supplements, and they made the point of saying, and how it does not regulate those products, both in terms of authorities, but also going back to the resource issue. So this sounds like maybe it could be a request for more money, both so that it can tell consumers that it's regulated these products more robustly than it can with existing resources. Maybe it's also an implied request for money because the agency wants to go on a consumer education campaign to make it very clear to consumers how it does and does not regulate supplements generally, and CBD supplements in particular. So I say maybe that's a request for money, or maybe it's just the agency thinking aloud about its concerns here. So what are the next steps on CBD? That joint explanatory statement that yielded the March 5th report also required the agency to perform a sampling study on the current CBD marketplace to determine whether products or which products are mislabeled or adulterated, and to provide the committees with a report within 180 days of enactment. Doing my lawyer's math, aided by Google, that deadline appears to be on or about June 17th, 2020. And then next steps, I think we probably could have come up with this list based on the presentation already, but just for review purposes, maybe an enforcement discretion policy, maybe clarity on CBD containing ingredients that don't qualify as the same article as Epidiolex or Sativex, and therefore could be marketed as dietary supplements or dietary ingredients, or used in the food supply, assuming all other requirements, including safety requirements, are met. Maybe a rulemaking to create formal regulatory exclusions for true CBD products on the supplement side, the food side, both, or maybe just one. And then possibly a congressional override. Certainly there are some legislators who are frustrated by the amount of time that this is taking, and the cascading impacts on their constituents, from hemp farmers to finished product manufacturers, to retailers, and maybe as well to constituent consumers. All of these things and others are on the table, and here's my attempt at a smooth transition to subject 2. maybe they aren't going to receive the attention and action on them may be delayed to a significant degree because of the impacts of the COVID-19 pandemic, which we'll talk about briefly here now. So really in the last few weeks, FDA and CFSAN, the Center for Food Safety and Applied Nutrition, the center within FDA that focuses on food supplements and cosmetics, has remained, laser focused on the pandemic, and that's taken a couple of different forms. One, virtually the entirety of the FDA workforce is working remotely when it's feasible, depending on what their job is. Which, as anyone who has small children who are out of school right now understand, is easier said than done, or at least easier said than done with respect to efficiency. FDA has also halted both foreign and domestic routine inspections of facilities for the time being, which means that only mission critical inspections like those related to a foodborne illness outbreak or a class 1 recall, or maybe even a pandemic related issue, will continue for now. And then as of April 6th, yesterday, FDA has been issuing warning letters to companies alleging illegal COVID-19 prevention, treatment, or cure claims for various products. As of today, the agency has issued 20 of these letters. 4 were released today, and many of these letters have been issued jointly with the Federal Trade Commission, and they're pretty starkly worded, requiring folks to respond within 48 hours as opposed to the standard 15-day response time. So beyond the effects on enforcement and the workforce itself, the agencies and CFSAN in particular has also taken a number of steps to ease burdens and bolster the food supply during the pandemic. And examples of how it's doing that I've included here, but some of them are fairly obvious. Not requiring folks to conduct on-site supplier verification requirements under the FSMA rules, given the travel restrictions and safety concerns. Perhaps less obvious, relaxing the requirements for dietary supplements as well as OTC drug serious adverse event reporting. Usually that's supposed to be done within 15 days, and the agency is saying you can hold them for now, and then at least within 6 months after the return to normalcy, you can provide them. But in the meantime, to focus on product safety related ones. The agency's relaxed some nutrition labeling requirement for packaged food sold by restaurants. Restaurants have a lot of inventory because a lot of them can't operate normally right now, and so they're allowing their restaurant labeled products that don't have nutrition facts labels to be sold to consumers. And likewise, restaurant labeled packaged food from manufacturers can also be sold on this temporary basis to consumers, even if those products don't have fully compliant nutrition facts labels. The agency's also said that in the interim, menu calorie labeling disclosure requirements for chain restaurants and similar establishments will be relaxed, and I think that's a reflection of how restaurants have had to change how and where they communicate with, in particular, their takeout and delivery customers. And last, before I hand it over to Dan, FDA has also communicated consistently and very firmly that there's no evidence that the novel coronavirus that causes COVID-19 is transmitted through food or through food packaging. And as a consequence of that, the agency doesn't expect that companies will have to recall or withdraw products from the market due to the pandemic, including if an employee tests positive for the disease. So with that, I can take questions. Sean, I'm going to defer to you on whether we just want to move into Dan's and return to questions at the end. But I really thank you for your attendance and attention and your patience as we dealt with our technical difficulties to start the program.
Well, hearing no objection, I'll start up. I'm Dan Dwyer with Kleinfeld Kaplan Becker Thanks very much to the folks at Vicente Sederberg for inviting us to help with this. My topic is on OTC drug reform as part of the CARES Act that was enacted a couple weeks ago. By OTC drugs, I mean over-the-counter drugs. These are the traditional over-the-counter drugs that you've seen in grocery stores and drug stores that you can pull off the shelf and use as you wish since time immemorial. So they're OTC drugs. And why, you think, why is Congress, in the middle of the biggest pandemic for 100 years, reforming the rules for these simple OTC drugs like analgesics and sunscreens and things like that? Well, there's no good answer to that, but I think the answer is that this OTC drug reform bill has been kicking around for a couple of years, and this gigantic CARES Act seemed like a good vehicle to get things done. So here it is. So what's new in a nutshell for OTC drugs? Basically, two things: user fees and exclusivity. These two concepts have been around in the prescription drug marketplace for, a generation now. And so now they're being superimposed onto the old-fashioned OTC drug world, and it's going to turn that old-fashioned OTC drug world on its head. So by user fees, I mean OTC drug facilities are going to have to pay fees, and requests for, quote, administrative orders. And we'll talk about what those are in a moment. And then exclusivity, well, that just basically means an opportunity for a short-term monopoly that's granted to a company to market exclusively, free from competition by generics or Me Too type products, for 18 months in certain cases. The key thing there is that the marketer has to have provided new human data studies in order to get approval for its OTC drug. What are the impacts of these two new provisions in the statute? Well, user fees will fund FDA's OTC drug functions, so you might be reasonable to think that that might lead to faster FDA approval of OTC drug issues. And if the past is prologue, that's certainly what happened with prescription drugs, so it's reasonable to think that that might happen for OTC drugs as well. And exclusivity, well, that's going to ideally provide a financial incentive to manufacturers for development of innovative new OTC type drugs. And again, if you look at what happened with the prescription drug industry, well, by golly, that's exactly what happened. Well, why are these changes important in light of the way that OTC drugs have been regulated in the past? To understand that requires a little bit of understanding how OTC drugs were regulated, and we'll just cover the very basics. Currently, OTC drugs are covered under what's called the OTC Drug Review, which began as an FDA regulatory program way back in 1972. And it covers categories of products marketed through 1975. Most newer products, with some minor exceptions, but not very many, aren't covered. So if you wanted to develop and market a new, clever, creative, innovative OTC drug since 1975, well, what do? You can't market it under the OTC Drug Review, or if you tried to, it would take forever to get it done. So you have to submit a new drug application to FDA's through FDA's new drug approval process. Now, the way that OTC Drug Review has functioned in the past is that they use monographs, FDA monographs, and they're basically regulations promulgated through notice and comment rulemaking. And as Will said, notice and comment rulemaking takes a long time. Indeed, some of the monographs that have been developed for OTC drugs back since 1972 still aren't final for many drugs. The best example is the drug that we all want nowadays, which is hand sanitizer. Hand sanitizers still aren't subject to a final monograph under the OTC Drug Review. So it's a slow process. The only alternative to this process for getting a new or innovative drug marketed is to submit a new drug application, which is a vastly more expensive process than going through the OTC Drug Review. So as a practical matter, the current system has squelched change. shut down and discouraged innovation and resulted in the fact that the OTC drugs in the marketplace that you can go out and buy now are the same darn drugs that your parents and grandparents were buying 1 or even 2 generations ago. So the new law may break this crazy logjam. Basically, the way it works is it freezes the current legal status of OTC drugs and then requires future changes in the process to be made by administrative orders that are not subject to notice and comment rulemaking. And as I mentioned, with exclusivity, it gives industry an incentive to submit some orders seeking changes, and with user fees, it gives FDA the resources to review them. Now, the way the new law works is that OTC drugs, in order to be legally marketed without a new drug application, need to be generally recognized as safe and effective and used to a material extent or for a material time. And in particular, they need to be safe for OTC use. That is, they need to be safe for self-medication. So, under the new law, FDA can issue an administrative order if it concludes that something is not GRACE, generally recognized as safe and effective, if it's currently marketed, such as an active ingredient, combination, dosage form, intended use, or if it concludes that a currently authorized drug is not GRACE. I think that I said that wrong. I think my slide got a little mixed up. But basically, FDA can go in and say that if something currently on the market is not safe, they can fix that by issuing an administrative order to either get the product off the market and change the labeling, or if they have a new and innovative product, such as an active ingredient, combination, dosage form, or intended use that's not currently authorized, they can issue an administrative order to get that on the market. Anyone can request that FDA issue an administrative order for any change to an existing condition of use. And with respect to exclusivity, as I mentioned before, if that request covers an active ingredient or a product change, and the request is supported by new human data studies essential to approval that were conducted or sponsored by the requester or for which the requester has a right of reference, then magically that requester will get 18 months of exclusive marketing rights. Exclusivity doesn't apply to certain types of changes, like certain minor changes, certain safety changes, but for most big changes like new active ingredients or new dosage forms or new indications, it could apply. Now, the user fees are going to be not small. For an administrative order to submit a request, you got to pay $500,000 for most requests. That'll change each year. Certain minor requests, and these are very minor, would only cost $100,000. And you're going to say to me, well, that's a lot of money. And how can I afford that? It's true, this administrative order request fee is a lot of money, $500,000. But compare that to what you'd have to pay to FDA just to get a new drug application submitted. Next year, that's going to be about $3 million. So the opportunity to submit administrative order requests for changes to OTC drugs is going to be the much less expensive option for purposes of this type of marketing. In addition, there will be facility fees. We don't know what those are yet. They'll be set by FDA and begin to be payable later this year. So what could this mean? The new law was going to mean, I think, that traditional OTC drugs are going to still be permitted, but competition is going to push those drugs eventually off the market and replace them with newer, more innovative types of products. I expect there will be a much more rapid evolution of the OTC drug marketplace in the future, and I mean fast in the future, soon in the future, than you've seen for the last 50 years. And there will be potential rewards for manufacturers that take the trouble to invest in studies and, in particular, plan for life cycle management. And by that I mean planning your product changes out so as to take advantage as much as possible of these exclusivity provisions that give you a monopoly in the marketplace. So, how would you develop a new OTC product? Well, first is to determine whether that new product would be generally recognized as safe and effective for an OTC use, and If it wouldn't, based on the current data, what new data would be needed in order to do that? And then determine whether similar products have a verifiable history of being marketed and safely used by consumers. Remember, OTC drugs are supposed to be drugs that are not completely new and innovative, but that have some basis in prior marketing. That might be prescription use in the United States, that might be some foreign use, or some combination thereof, or the marketing of analogous products. You can be creative. And if you can answer yes to these kinds of questions, then the administrative order may be your way forward. How to proceed? To develop a plan, discuss it with FDA for guidance, and this may be a collaborative effort among industry members. Is there an opportunity for hemp here? Well, there's not been a monograph covering hemp products in the past, so probably it's an uphill battle, but could it be generally recognized as safe and effective for an OTC use? Something like CBD for minor pain, for example? Maybe it could. It might provide an opportunity worth exploring in order to be protected from future regulatory challenges, class action lawsuits, and other things that might be the monsters at the end of the tunnel waiting to nip at products like CBD that get ever the more popular. And with that, I'm going to move on to our friends at Vicente Sederberg for the next part of the presentation. Thanks very much.
Thanks, Dan and Will. I'm going to save the questions for the end, and we'll hit some FDA questions and questions on the emergency orders at the conclusion. So shifting from FDA to kind of some immediate issues facing businesses, and specifically I'll discuss the impact of the emergency directives and executive orders on hemp businesses. As many of us, or almost all of us, are in states with stay-at-home or shelter-in-place orders, and in many places there's local, state, and federal orders, and a number of different issues to consider for businesses all across the supply chain. So I'll outline kind of how to navigate these orders and what it means for hemp businesses. So federal disaster relief is generally structured to rely on the state and local police powers in responding to public health emergencies, and with the federal government providing really a supplemental supportive role. And shelter-in-place orders usually identify certain industries as critical or essential businesses that are exempt from the orders to shelter in place, and those businesses can stay open and are considered, critical to the national emergency response and the national infrastructure. Unless there's a direct conflict, the state and local orders will govern, and the federal law won't preempt those orders. In most states, the statewide orders preempt the local orders, and the orders have not been delegated significantly to locals, with notable exceptions, including Texas and California, where there is some patchwork of local orders and a sort of a local overlay. And there has already been a number of cases of states exercising their authority. In Texas, for example, when some localities tried to close gun stores, the state confirmed they didn't have the authority to do that and halted those closures. In Mississippi and South Carolina, state officials issued orders and opinions blocking local governments from ordering business closures, claiming they exceeded their local authority. In other states, statewide orders supplement local orders and really set the floor. So it's important to look at the state and local orders in your state, including looking for any preemption language that may be in the state and local orders, to determine what your responsibilities and obligations are, and to determine whether your businesses are essential. Typically, these orders require all business to stop unless they're expressly exempted. In order to determine whether you're exempted, you want to look at the description of the industry, the description of the types of employees within your industry that are exempted, and any specific special exemption by order or agency determination. And if you are exempted, looking at the requirements to continue operating, which generally include social distancing and other health measures. The timing of the orders and enforcement mechanisms really vary across jurisdictions. Many of them end in April, although we're already seeing extensions in many states, including Colorado. These are criminally enforceable, and criminal enforcement is often focused on the business rather than individuals, although there have been some individual citations as well. In going back to determining whether your business is considered an essential business, in general, healthcare and food supply and production, as well as agricultural businesses, are deemed at the federal and state local levels to be considered essential. And that includes kind of grocery stores, folks all along the food production supply chain, and also government services, emergency services, news outlets. But for the hemp industry, many businesses will fall under the food production, or healthcare umbrellas, and depending on your specific business and your specific state of operation, it's important to understand what exemption you potentially fall under, and then what your related obligations are. And it does mean that not only are you essential, you're encouraged to operate, you're considered critical for the nation to manage its emergency response, and for the support and security of the country during the crisis. The critical nature of the food production and health industries is clearly set out in the presidential policy directive, where 16 critical sectors are identified, including food and agriculture and closely related sectors such as transportation and commercial facilities. And the Department of Homeland Security, Cybersecurity and Infrastructure Security Agency issued guidance in March that was then updated on March 28th, clearly outlining what constituted the essential critical infrastructures workers. It also included 16 sectors that included food and agriculture, which had a wide range of food industry workers, everyone from the grocery employees and employees of pharmacies to those that sell human food, animal, pet food, beverage products, and everywhere from the sanitation inspector to the food grower and producer. It also was updated to include under the healthcare and public health sector manufacturer workers for health manufacturing, including dietary supplements. And that broad designation likely includes companies along the dietary supplement supply chain, including the ingredient suppliers, distributors, manufacturers, and testing labs. And in addition, certain analytical testing laboratories are listed separately as essential under a different sector category. So this is positive, and also a call to duty for food production and dietary supplement businesses, including those making hemp and hemp-derived products. Although the Homeland Security Cybersecurity and Infrastructure Agency guidance is advisory in nature, it was developed in coordination with state agencies and is given significant deference. And most state orders have essential business determinations that mirror or are significantly similar to the CI designations, and often include food and agricultural workers. There has been some debate in certain states as to whether certain hemp retail outlets that are not necessarily grocery stores or other natural food stores, whether those constitute essential businesses. And those determinations are looked at on a state-by-state basis, but I know there's challenges in states like Texas that have proceeded favorably for the hemp and CBD retailers, and other determinations are being looked at individually. Also important to know that the federal designations and recognitions of your businesses as essential don't preempt a determination under federal or under state or local law, but they may support a determination or argument that your business is exempt. So it's important to understand the designations and guidance relating to your business that's come down from the federal government. And there's great resources on the government website, for the Department of Homeland Security's website, and they continue to update them regularly. So I would encourage anyone who has any questions to look at that website. Just some tips to navigating these state and local emergency orders. Continue to monitor them at all levels. They are being updated in real time and have important changes frequently. Looking at the local and state level, everything from your local health department to your mayor's office. In addition to orders, there are generally FAQs and guidance documents that really help explain these issues. And then understand whether your state orders preempt local orders, and what the specific preemption issues are in your state. If there is a conflict, looking to the state law to see if there's express preemption language is usually a quick way to address the issue. And also relying on your industry and government contacts to resolve any issues. These orders are often written quickly, and sometimes the government agencies need to come back with clarity where preemption or other issues weren't addressed. It's important to know and monitor your effective dates and durations, understand the geographic areas of the state covered, and really what your obligations are as an employer, not just to keep your business operating, but to keep your employees safe, to keep your products safe, and to keep every other business in the supply chain as supported and safe as possible. If you're having issues sustaining operations or not sure whether there's going to be barriers in any of the states in your supply chain and getting your goods to market, pointing to federal guidance is helpful. Having your any food certifications or licensure on hand, and then working with other industry organizations and trade associations in the natural and herbal product space and the hemp space, local agency contacts and other allies is really critical to make sure we all have continued operations and are really in this together to support the survival and continuity of our businesses. And there's a lot of great resources out there from the trade associations and others. And just say, remember, it's as we continue to advocate and operate as the industry is considered essential in various states, it's just critical to enforce these safety guidelines and standards in your businesses and with your employees, and to have vigilant oversight over the safety of your businesses. And on that note, I will turn it over to Corey, who's going to talk about some of the best practices and steps business can take to maintain these strict safety protocols and operate through these emergency orders.
Thanks, Sean. So I'll be concluding the program today about with the common issues we're seeing hemp businesses, both with respect to general emergency orders and operating in an emergency environment, as well as considerations stemming from the general economic and financial climate. Also provide some brief practical considerations for operating in an emergency environment. And then we'll conclude with a brief update on state legislative sessions and how the COVID pandemic is impacting actions at the State House. And so starting off with some of the common issues we're seeing impacting hemp businesses, I think that the starting point is really understanding the applicability of the emergency orders Sean just discussed to your business. And so hopefully kind of after this program, you'll have a framework and pathway to review these emergency orders and determine their impact. But that's really the starting point here, is reviewing the emergency orders to determine whether your business is critical, whether it's essential, or the terminology used in your jurisdiction, or whether you need to implement some type of temporary closure until these orders are in place. I think once you've established that your business is critical or essential, I think the next step is identifying whether there are special conditions under the executive order that your business must implement in order to continue to operate as an essential business. These are typically heightened social distancing requirements, for instance, 6-foot spacing requirements between employees, or heightened sanitation protocols with respect to hand washing, regular cleaning, facility maintenance, those types of things. And so I think once you've established that your business is essential and is meeting the minimum baseline requirements to operate as an essential business, I think the next step really to kind of look at and evaluate what your legal obligations and responsibilities are to your employees with respect to personal protective equipment or paid leave or types of considerations. And then additionally, given the financial and economic climate, understanding what your options are as a business to kind of control costs by perhaps reducing your workforce or reducing salaries or taking other emergency measures to provide some more financial flexibility or liquidity in your business. And then the kind of last level of issue seen is just general logistics and supply chain. So once you've kind of established that your business is able to operate and has a framework for operating kind of safely and effectively, I think the next step is to see whether your partners in the supply chain, whether it's suppliers or your retail channels or vice versa, are similarly situated where they're able to keep operating. As Sean noted, most grocery stores and food infrastructure is deemed essential and able to continue operating. But if you're selling through retail channels like a specialty CBD store, maybe vape or smoke shops, or massage or spa, your traditional retail channels may be limited due to temporary closures. I think it's important to have conversations and engage in active communication with partners throughout the supply chain to ensure and just understand kind of what's the level of functionality throughout and ensure you're prepared. And so, and if given these emergency considerations, I'm going to touch on some practical considerations for operating in this environment. I think the first point is just to really understand and appreciate that we are operating in a really unprecedented situation. Conditions on the ground, especially from a regulatory perspective, are rapidly changing. The situation is very fluid. And as such, it's very important that you have a mechanism in place to identify changes in regulatory requirements, such as new executive orders, and to relay that information to decision makers in your company so you can identify whether changes in operations are necessary and to implement those changes as smoothly and quickly as possible. Another important consideration is to ensure you have written protocols that implement any social distancing or heightened sanitation standards under executive orders or similar emergency measures. We all know that if it's not written, it didn't happen. And so important to start creating a written record that you basically understand the requirements, that you're taking steps to comply with those requirements, and have basically written documented evidence to support that. If you're making substantial adjustments to your standard operating procedures, try to train employees on those policies, make sure they're aware of what their expectations and responsibilities are under revised emergency operating procedures. And then finally, ensure those SOPs or other emergency steps are for inspection if regulators have come to check in on you. Additionally, I think it's in addition to written materials, it's important to implement physical, visible signs that regulators and employees or workers can look to and and quickly understand that you are following guidance and executive orders and taking concrete steps to comply with those and to protect the health and safety of your workers. So, and to use a 6-foot social distancing requirement between employees as an example, if that's required in your jurisdiction. I think doing things like marking 6-foot spaces with tape on the floor, or using cones or other types of kind of temporary barriers to really establish what that 6-foot distancing looks like, provides a very clear, concrete signal to regulators that you're making a good faith effort to comply and implement their emergency requirements. And it also provides your workers or employees with just a concrete, visible action that you as an employer are doing to protect their health, safety, and general well-being. And then it's also important to consider whether you need to revise or adjust your employee policies in this emergency climate. And so one thing that comes to mind, and has likely been implemented already, is just steps to reduce the number of employees that are physically present at a facility at any one time. And so this could take the form of telecommuting or work from home to the extent that's possible. And then when that's not possible, whether you can stagger shifts or kind of alter your workflow to allow for less employees to be together in the same space at the same time. Additionally, if additional personal protective equipment is available and warranted, and you can make that available to employees, that's something to consider here, as well as increasing the availability of sick days. So employees that are exhibiting symptoms don't feel kind of pressured to come to work where there's this real risk of spreading the virus throughout your workforce and potentially setting up your business for a disruption in your workforce that could lead to prolonged disruption or even closures. And this could include directions to your workers or employees as to when to stay home. As if you're exhibiting XYZ symptoms, don't come to work, stay home, address it later. And I think these are important conversations to have with counsel, employment counsel in particular, is to make sure you're kind of threading the appropriate needles and satisfying your legal obligations as an employer as you work to protect both your business and your employees. And then with respect to the financial considerations, realize this was a increasingly challenging business environment before COVID, and COVID has really put tremendous financial pressure on many businesses in this space. So luckily, there are a variety of relief measures intended to make additional money and financing available to small businesses. Many hemp and CBD businesses are available to access these funds. And these are business loans from the SBA. There's payroll protection measures you can apply for, and then disaster loans or emergency loans from the FSA under the umbrella of the USDA. So these are available. We'll get into the details of them now, but we have their content on our website diving into these various relief measures in more detail. So that's a great place to look for more information. But despite the kind of availability of these various relief measures, there are some unique challenges we're seeing for hemp businesses. One of them is the kind of books and records that are required to access some of this federal money. And businesses need to provide or have to document kind of what their potential lost income may be. And so if you have kind of sales contracts or other things that can support what your projected kind of revenues and losses here are important. But a lot of businesses in this space are startups and may not have the documents in place to satisfy the criteria they're looking for here. There's also tremendous variability between different financial institutions. And a lot of this money is doled out to banks to kind of lend to different businesses in their discretion. And as many of you are aware and have experienced over the last few years, there's still significant resistance in some banks and financial institutions to providing banking and financial services to hemp and CBD companies. And so we anticipate that some of that resistance will continue. Understand that that is largely and if determined by individual financial institutions. And so if you apply for a loan through one bank and your business is rejected by nature of working in the hemp space, we encourage you to apply for a different financial institution where they may have different policies and procedures in place with respect to hemp and CBD businesses. There's also potential that whether your state operates a 2014 Farm Bill program or a 2018 Farm Bill program could impact the availability of loans. And this is a specific issue with respect to the FSA loans or financing available through the USDA. And what we're kind of seeing so far is that businesses operating under the 2014 Farm Bill, which includes states like Colorado, is that those businesses are not kind of able to access this money, and that they're instead must be operating under a 2018 Farm Bill. And the reasoning we're hearing for this is that the 2014 Farm Bill has a predetermined sunset date. It's the end of October of this year. And so kind of due to that sunset, the compliance of a business under the 2014 Farm Bill is inherently in question. It has this kind of concrete end date at which there's additional licenses or registrations that must be applied for. We've also heard that the FSA views the 2014 Farm Bill really as a research-focused program. And so with those limitations in mind, whether your state has a 2014 Farm Bill plan or a 2018 Farm Bill plan could impact the availability of funding in some situations. And then finally, as really highlighted by Will at the beginning of this program, the FDA has a very complicated relationship with CBD. And so for businesses that are engaged in CBD activity in particular, there's potential, if given the FDA's general disposition towards those products, that banks or certain other financial institutions may be more resistant to provide loans or kind of access to federal relief money to those businesses. But with all that in mind, these kind of avenues of funding are generally open to hemp businesses, and we encourage you to apply sooner rather than later if these are opportunities you're interested in exploring. And then finally, we want to touch on the impact that the COVID-19 pandemic is having on state legislative sessions. And in short, many state legislative sessions have been suspended. They'll either resume and continue in full after the pandemic, or some have been potentially truncated and will have shortened sessions. And especially in states where they may need to finalize the state budget, we can't kind of bank on hemp to be priority legislation coming out of this emergency environment. And so we fully anticipate there will be delays at the state level, basically aligning state law with the 2018 Farm Bill. And that could result in delays developing and submitting 2018 Farm Bill plans to the USDA. And as a result, there's some maybe movement or efforts to try to extend the 2014 Farm Bill. At this point, we can't really speculate the likelihood, but there's efforts in place. And then it's also possible that just the COVID pandemic could delay rulemaking and implementation of statutes that have already been passed. Maybe a hemp program was created last year, but regulators were tasked with developing different labeling and testing requirements this year. And the development of those regulations may be delayed or put on pause as state and local regulators work through COVID and the fallout of this pandemic. And then the last consideration at the state level, and this is also kind of mirrors what we'll discuss with respect to the FDA and the warning letters they've issued to companies marketing products for unscrupulous COVID claims, is that this could very likely result in a shift in enforcement priorities at the state and local level. Before COVID, we were aware of some states that were considering implementing kind of THC caps on products, whether that was per serving or per product. And following the outbreak of the COVID pandemic in the US, we've really seen a kind of pause on those conversations. Similarly, there was a kind of growing discussion among state attorney generals to really look at the kind of claims surrounding CBD products, the kind of marketing materials, and it's done from a kind of consumer protection perspective. Again, with the COVID pandemic and the very pressing kind of health and safety issues surrounding this pandemic, we really expect that these state agencies will be shifting their resources to focus on COVID and related fallout, and that kind of reviewing CBD marketing claims may be less of a priority. That's not to say you shouldn't care about your claims. You still are a major exposure for your business, and you should do everything you can to be as compliant as possible and mitigate risk where possible. But I think it's important to understand that the enforcement priorities of regulators and that the resources available for enforcement, especially at the state and local level, may be materially different kind of coming out of this COVID pandemic than they were 6 weeks ago. With that, we'll pass it back to Sean for questions and concluding remarks.
Sean, don't forget your microphone.
Sorry, guys. We'll take a few questions real quick and then wrap it up. I think the first question here is for Will. What does it mean that the FDA halted inspections as far as cargo not coming in or going out?
Right. Sorry, that's inspections of facilities, routine inspections that the agency conducts to ensure, for example, that companies are complying with good manufacturing practice regulations applicable to the category of goods that they produce. It's not, to my understanding, related but distinct import inspections that occur when an entry is offered for importation in the United States. Dan, if you have a different view, please chime in.
Okay, I don't have a different view though.
And then couldn't the FDA form another division with a primary focus on CBD? And I know there was a advisory group, but Will, do you want to speak more to the practicality of a CBD focused group?
Well, the agency has some flexibility or discretion to create different organizations within its structure. Some of it is controlled by statute, but whether the agency creates a working group or a separate program related to CBD products, that doesn't resolve the underlying technical issues about what authorities FDA can regulate CBD products under, and under what categories companies may lawfully market a CBD product. So, until on the supplement and food sides in particular, until there's resolution of this stalemate of sorts between FDA's interpretation of what the law requires it to do here, either through rulemaking or temporarily through an enforcement discretion policy or through congressional override, these problems will remain, and these barriers will remain, and no amount of internal reorganization of the actual agency will make a difference there.
Helpful. And then to a couple of folks here asking whether the slides and webinar recording will be available. They will. We'll email that out to everyone shortly. And thank you all for your time and great questions. More to come in 2020 as FDA's regulatory approach progresses and the industry adjusts and come out of this national emergency. So please don't hesitate to reach out to us or Will and Dan. And thanks, Will and Dan, for taking the time to join us, and for everyone for your time and attention, and thinking of you all, and be well.